Welcome back to the channel, folks. Buckle up because today's case comes at you, fast, loud, and messy, just the way courtroom drama should be. Before we even hit the 30-second mark, we have a landlord who just bought a property, a tenant caught in the middle, and a judge who is about 2 seconds away from losing all patience. Now, if you're new here, let me set the stage. This is a classic showdown where a landlord believes he can rewrite reality simply by showing up at someone's door and calling it a day, but the law, as we all learn, eventually does not work on because I said so. You're about to meet David Sawolski, a new property owner who walks into court with a laundry list of accusations, a rental rate he can't prove, and a security deposit situation that looks like a maze with no exit. On the other side is Lisa, the tenant who claims she already paid a $2,400 deposit to the previous landlord. And right in the middle is the judge who has zero time for guesswork, assumptions, or my buddy told me legal theories. Pay close attention because every sentence in this case snowballs into something bigger. We're talking miscommunications, legal missteps, and a landlord who may have accidentally built his entire case on sand. Stay with me because the twists come fast, and the judge is about to teach a masterclass in landlord-tenant law that every new property owner should be forced to watch. Millions of dollars and years of headaches could be avoided if people simply understood what you're about to hear. Let's jump in.
David Sawolski versus Lisa Lauro. Lisa Lauro. And what about Maria?
She's there.
Okay. Your name, sir?
David Allen Sawolski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is you did file it?
I wanted, sorry. I wanted a 1.5 month, $2,400 security deposit. And, now she owes $3,200 in, back rent because, I took over. What happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so, for her to stay there, I would want $1,600 per month, but that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at
This moment right here tells you everything you need to know about how quickly a case can turn. The judge is quietly setting a trap, and David walks straight into it. When you purchase at a property, you don't get to hit reset. Like a video game, a tenant doesn't suddenly get new rules. Just because there's a new name on the deed, the law requires stability and advance notice, not surprise announcements at the front door. This is where a lot of new landlords slip up. They think a conversation counts as a contract. Spoiler alert, it doesn't. And the judge is about to drive that point home hard. Would you want your rent jumping with no warning?
At what point did you give her notice that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it, and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were going to charge $1,600 for October?
Yes, sir. If she paid
then
it,
let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
We had no agreement.
Your Honor, he came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my daughter.
Now this is where the case takes a turn that makes everyone shift in their seats. Anytime personal comments slip into a financial or legal discussion, judges take notice. Whether he meant it innocently or not, it shows a blurring of lines that can damage credibility fast. The courtroom is not the place to bring compliments, negotiation pressure, or emotional appeals. The judge wants facts, agreements, and written proof, not side remarks or vibes. And for Lisa, this becomes a key detail because it reinforces that the agreement, David claims, they had was never clear, documented, or professional. Always keep business strictly business. Do you think this comment hurt his case?
My dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
Did
I
you tell her that?
24
No,
hours
sir.
to think about it, and I called him back and said,
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, for her to stay there, I wanted,
No.
okay,
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
yes, sir.
And in that complaint,
Yep,
you basically indicated that, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing,
Here's where the judge starts pulling the filing apart, layer by layer, and it isn't pretty. Leaving essential sections blank in a legal complaint is like turning in a test without filling out the answers and hoping the teacher still gives you a passing grade. Courts rely on documentation, accuracy, and specific numbers. When you claim someone owes you money, you must list exactly how much, when, and why. Anything less raises red flags. David filing a rent complaint without completing. The amount owed section isn't just a small mistake. It undercuts the entire foundation of his claim. Think about it. If he can't document the debt, how can he enforce it?
hearing is that is not true. And
I originally offered her, sir, 1,200 if she paid me that same day.
okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties. And assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent. Yet you filed a complaint that says that the rental rate is $1,600. Frankly, sir, that's false.
Okay,
Then you don't say you say no rent is due, right?
which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that. I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one. That's why I feel.
Well, hold on. Just hold on, ma'am. Just
What
take
I,
a breath, please. All right. How much did you pay as a security deposit?
It was 2,400.
Thank you. So if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was
And-
a,
I'm
sorry.
And he told me he had no
I don't-
security deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. That security deposit that is she previously paid, and any security deposit the tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice.
This is one of the most important lessons in all of landlord-tenant law. Security deposits are not a tip, a gift, or a down payment on property ownership. They legally belong to the tenant until damage or non-payment justifies a deduction. When you buy a property with a tenant already living in it, you inherit their lease and their legal protections. The fact that David never verified whether a deposit existed is a critical error. It's like buying a car without checking if it still has a loan on it. The judge knows this, and he's giving David a reality check in real time. This is why due diligence matters. Landlords, would you risk a lawsuit over an overlooked deposit?
Twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages.
Okay.
So that's where we are. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third
Yes, sir.
on my say so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the 1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit.
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my pre.
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof. But I don't see anything in the beginning of this that you did that's right.
When a judge states something this direct, you can practically feel the temperature in the room drop. Most judges dance around language to stay neutral. But here the court is sending a message. Every critical step was mishandled. This isn't just a mistake or two. It's a pattern of decisions made without understanding the law, and judges don't like cleaning up avoidable messes. Notice how David keeps asking what Lisa must prove, but never what he should have confirmed before filing. That's backwards. In court, the burden always falls on the person making the claim. If you file, you prove. If you accuse, you bring evidence. David didn't, and the judge is done letting it slide.
At all. Have you asked the previous landlord if he has a security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are going to end up getting sued.
This is the moment that should make any landlord sit up straight. The judge just essentially warned David that his actions didn't only fail to support his claim, they potentially exposed him to a lawsuit. When you mishandle security deposits, misstate rent, and file inaccurate court documents, you don't just lose your case, you risk paying damages. With housing law, mistakes add up fast, double deposits, incorrect notices, improper rent increases. They all carry financial penalties. And the judge is making it clear that if Lisa chooses to fight back, David may have a bigger problem than unpaid rent. Would you take that risk just to rush into ownership?
So my question becomes, what do you want to do with this case?
Well, indeed, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yeah.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see what.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
Okay. I'll contact.
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint, and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
Well, I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights.
Well, because if she put it,
sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances, not sure that was any of your business, but that okay, you took the place, didn't get her security deposit, ask her for another security deposit, and then try to increase her rent by a third. So here's what I'm going to do. Okay. I'm going to adjourn this out 1 week. You think about it. You try to figure out. I'd suggest you go get an attorney. Because if she turns around and files a claim, you're going to have a heck of a time. I'm just going to be honest with you. But that's going to be your call. I am not, because it's not in her interest. She's unrepresented by counsel. I'm not going to, and she's appeared. While you're moving to dismiss, I'm not granting your motion to dismiss at this time so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you.
This closing exchange tells you everything about the power dynamics at play. The judge is giving both parties time to breathe, reflect, and seek professional guidance. But notice the subtext. He's strongly advising David to get a lawyer because the road ahead won't be easy. And he's protecting Lisa's rights by keeping the case open. This is how courts ensure fairness when one side arrives unprepared. The judge isn't taking sides, he's taking the law's side, and he's making sure neither person gets steamrolled by process or misunderstanding. This is the moment where you ask yourself, was this whole case avoidable? What a journey this case has been. We watched a landlord walk into court believing he had a straightforward claim, only to discover that every step of his approach violated basic legal requirements, from failing to provide written notice to misunderstanding security deposit law to filing an incomplete complaint. David's case collapsed under its own weight. Meanwhile, Lisa demonstrated why tenants must know their rights and speak up when something feels off. The judge's ruling didn't just clarify who was right or wrong. It reinforced a larger principle: property ownership comes with responsibility, not just authority. And when you fail to respect those responsibilities, the court will hold you accountable. If you found this case as surprising and eye-opening. As we did, make sure to like the video, share your thoughts in the comments, and hit subscribe so you don't miss our next breakdown. Courtroom lessons like these are too valuable to miss.